Being here this afternoon. To begin with, I want to recognize Councilor Dolan for a moment of reflection and for leading us in the Pledge of Allegiance.
Thank you so much, Governor. In a time when many are questioning our system of government, which has been shown over centuries to be the best form of government in the world, I'd like us to reflect on the fact that Massachusetts continues to uphold our historic values. As we stand in the Governor's Council chamber, specifically to refer to the Supreme Judicial Court, which has shown in recent years in a number of courageous decisions that they will continue to uphold our historic values. And as we get ready to swear in a new representative, Hannah Brown, I turn to the sage of Concord, Ralph Waldo Emerson, who wrote, "The end of all political struggle is to establish morality as the basis of all legislation. Morality is the object of government."
You're here.
Pledge allegiance to
the United States of America, and to
the republic
which stands one nation under God,
Indivisible.
liberty and justice
For all. All right, everyone. Get started.
Whoa.
You okay? All right. It's par for the course today.
Yes.
I know we have 5 new nominations to announce today, so one of which is Patrick Burke to the position of Associate Justice of the District Court. Councilor Dolan, I don't know if you have a date and time for that hearing.
I have a date, it should be next Wednesday. I'll confirm the time with the nominee and get back.
Perfect, okay. Next up, we have Brian Doxtator to the position of Associate Justice of District Court. Councilor Kennedy,
I believe that's
You know,
another
right.
district, and he's tied up for the moment. He'll be here later, and he told me that he would schedule that administratively later, along with the next one.
perfect, along with Suzanne McDonough to the position of Associate Justice. Okay, so those are the 2 of you are going to coordinate on that. And then I know we have Edward Karkasinsis to the Associate Justice of the District Court, Councilor DiPaolo. Do you happen to have a date and time for that hearing?
Yeah, we're gonna do Wednesday, the 28th at 10:30.
Okay, and then Liza Williamson to the position of Associate Justice of the District Court.
Yeah,
That's Councilor Ferreira.
He's going to schedule that
You're
separately.
playing air traffic controller these days for these,
Yeah, let me alone.
we say. And at this point in time, I'd like to invite the governor in to certify votes cast on the May 13th special election, and I will take my seat as a member of the council while she does that.
Thank you.
Welcome, Governor.
Good morning. Nice to see everybody. Thank you, LG. Well, good afternoon at this point, everyone. We're here to comply with the Massachusetts Constitution and the general laws relative to the tabulation and certification of votes cast in the May 13th special election to fill a vacancy in the House of Representatives. I recognize Councilor Kennedy for a motion to record certification that Hannah Louise Bowen has been elected representative in the general court from the 6th Essex District.
I make that motion, Governor.
Is there a second?
Second.
That's a voice vote, Governor.
All in favor?
Aye.
The ayes have it. Immediately following this assembly, we'll be gathering in the ceremonial office. I welcome you next door to where I'll be administering the oath of office to newly elected Representative Bowen as a member of the House of Representatives.
Okay, we stand adjourned.
We stand adjourned? Okay. Our business is concluded then. Meeting is adjourned. Thank you.
All right, we're gonna call this hearing to order. And I'm going to start by reading a letter from the governor. You tired of hearing these letters? You seem to hear them a lot.
No, sir.
Huh?
I'm not tired, no.
All right. It says, "Dear councilors, I'm pleased to nominate Asha Z. White to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I'm enclosing the nominee's resume for your convenience." All right. I'm going to introduce the councilors. We have Councilor Iannella, Councilor DePaulo, Councilor Jacobs, and Councilor Dolan present at the moment. And with that, we're going to call your first witness, the Honorable Jason Chan, second justice, maybe presiding justice if things go well today, of the Woburn District Court.
Thank you, Commissioner.
Don't assume it's going to go well, though, Judge.
Why do you not assume anything, Commissioner? Thank you everyone for having me here today. Thank you for all the counselors giving me this opportunity to speak on behalf of Judge White, who had the opportunity to serve essentially at Woburn District Court. He's been a tremendous leader for the court. I can convey to everyone here that the court certainly is going to miss his leadership. Seeing him preside over criminal cases in the civil session and doing criminal and civil jury trials was extremely impressive. His legal acumen is only surpassed by his kindness and compassion. I am very happy that he's going to be able to serve the Commonwealth and continue to serve the Commonwealth in a capacity of, hopefully, if the counselors allow it, in the role of Superior Court. They're getting a fantastic human being in terms of character, in terms of legal acumen. We are all very excited to have him essentially live out his dream into the next step of his career. But we will all miss the leader of the Woburn District Court that has been great to us all. So that's all I have to say, but if there's any questions from the counselors.
Does anybody have questions for the judge? Just a comment, Judge, you're doing a great job up there.
Thank you so
So
much.
I feel that way. I see how I've been in front of you. I've seen you on the bench. You're doing a fantastic job. You know Michelle French's, but you're as close as you can get. Hey?
Agree. Absolutely agree.
All right, thank you, Judge. Next, we're gonna call the Honorable Michelle French's, who sits in the Brockton District Court. You know, there was a possibility we might have had Dave Frank here, and I thanked Judge White for the upgrade.
Good afternoon, counselors. It's a pleasure to be here before you today. Unlike Judge Chan, this is not from the memory. I have to speak from what I'd already written. Otherwise, I lose my place. In any event, it's a pleasure to be here before you all today to offer my wholehearted support for my friend and colleague, Judge Asha White. When Judge White asked me to testify on his behalf, I have to admit, I hesitated. Not because I doubted his qualifications at all, but because I selfishly do not want to lose as a colleague in the district court. Judge White has been my indispensable partner, my right hand as co-chair of the District Court's Committee on Race and Ethnic Fairness. Together, we've led this committee with the mission of educating every single district court judge in the Commonwealth, whether newly appointed or nearing retirement. That's over 150 judges. The content we deliver is not easy. It's deeply personal, multifaceted, and demands an honest introspection of our entire department. Our work confronts the critical issues of systemic inequity, bias, and the responsibilities of the judiciary to meet those challenges head on. We've tackled findings and recommendations from key sources, including the 2020.
Come on, court, you can't look at me like that.
Including the 2020 Harvard study examining racial disparities in the courts, the 2021 report from the SJC Standing Committee on Lawyer Wellbeing, which distilled insights from Affinity Bar Town Hall meetings, and the data we've assessed in our leadership roles on the committee. Judge White's contributions have been nothing short of transformative. Over the past few years, we have led and developed educational programming on a range of topics, Commonwealth versus Long, including organizing a powerful panel of Black male judges who candidly shared personal experiences with pretextual stops. The use and impact of body-worn cameras, the emerging adult population, the neuroscience behind their unique developmental needs, and how courts can better understand and serve people living in poverty or experiencing homelessness. Judge White's dedication to this work has been unwavering. He pours himself into every aspect of his role, and his absence will be deeply felt on our committee and in the district court. But what we lose, the Superior Court gains. In my view, Judge White surpasses the qualifications for this role. His professional journey from prosecutor, defense attorney, assistant attorney general, and assistant clerk magistrate to his service as an associate justice in the Woburn District Court reflects a progression and breadth of experience that uniquely prepares him to be a justice on the Superior Court. He has managed a courthouse, maintained a demanding teaching schedule, supported his family, and helped guide the entire district court judiciary through challenging but necessary conversations about justice, fairness, and equity. In short, Judge White is a superb nominee, and it's my suspicion that you all know that too. I pray that he receives each of your votes for appointment to the Superior Court. Thank you for your time, and I also thank Judge White for honoring me with the privilege of speaking on his behalf.
Okay, so does anybody have any questions for the judge?
One comment, which is to thank you for mentioning Commonwealth versus Long. I think it's one of the most important decisions the SJC has handed down in recent years, and I'll be asking the nominee about this.
Wait a minute.
Oh.
Wait a minute.
I'm sorry.
Not done yet.
Apologies.
I said it all, so there was.
I was gonna ask you a couple of questions about the bar advocates,
Happy
okay?
service.
You know you got a work stoppage coming.
Heard.
You're gonna stop taking cases. I'm told that the trial court sent out a memo believing somehow that this, I haven't seen it, but it's gonna be a one-day deal. You know it's not, right?
That's my understanding of this.
It's gonna be until they get some type of appropriate reaction from the legislature. So that means for a long time, you're gonna be sitting in Brockton Court with a lot of 58As being filed and bail requests being filed and people in the dock, and you're not gonna have a lawyer for them. What are you gonna do about it?
Do my best to honor the Constitution and the Declaration of Massachusetts.
Does that mean the guy gets out or he stays in?
It's on the specific facts and circumstances of the case, but I certainly will do my best to uphold the oath that I took as a judge of the district court.
You should have run for office. The answer, huh?
I'm doing right now.
So not say anything. That was great. You know that do you understand what you would agree with me that I'm not a bar advocate. You know, I'm a private defense lawyer, but the bar advocates do the bulk of the labor in the district courts, especially and Superior Court, but they're the backbone, right?
I can't speak for every community, but I can tell you that in Brockton, we have a phenomenal bar. Bar advocates.
Guess what? I can't. I go everywhere, as you know. They are.
I think they're phenomenal. They do a lot of work, both in the courthouse and outside of the courthouse.
Yeah, right.
A number of our bar advocates who volunteer for our mock appeal program, mock trial program within our middle schools. And so I truly appreciate what they do, and I do hope that the legislature acknowledges that.
Okay, do you know that they do about 80% of the appointed work? And
I just learned that today. I didn't realize it. I guess if I were really paying attention to who's getting what cases, how many of them are in the courtroom, I would have noted that.
80% of the people who are appointed lawyers are appointed bar advocates, public defenders, part of the bar advocate program. And most people who end up before the courts, as you know, end up with public counsel.
Right.
Yeah, so that means they're doing the bulk of the work there. Now, I'm just gonna talk about the pay real quick and then I'm gonna let you go. I promise you'll be able to stand up and walk away, huh? You've just seen the other guy. He didn't go good for him. Massachusetts pays $65 an hour for bar advocates. And we have probably one of the highest standards of living in the state. New Hampshire, $112, almost twice. Rhode Island, $112. Maine, $150 an hour. Vermont, pretty rural, not a big population, not as high a cost of living, $100. Connecticut pays $88 to $102. And New York pays $158 an hour, which is probably the most comparable to the state we're in. $65 an hour. You think they're underpaid?
I think that number reflects a testament to the responsibility they've undertaken and the fact that they still show up day in and day out and perform a tremendous amount of work for people who are poor and deserving of their representation.
The other problem they have, and I talked to Judge Raschuti about this, and not so much, and I can say right now, not with any of the judges in this room, some judges kind of beat them up a lot, you know?
I don't think I have that reputation.
Huh?
I don't think I have that reputation.
You don't. I said nobody in this room. Some do, and have expectations of them that aren't reasonable given their workload. The other problem you have is a lot of the people end up in custody, which creates a whole nother layer of work for them with 58 days and things like that. I'm just pointing it out. It's my bully pulpit. I promised all my colleagues and friends that are bar advocates that I would do that. And I know one guy that was a bar advocate for 10 years who was a tremendous bar advocate. He did an incredible job as a bar advocate, a nominee today. All right? Done.
Okay.
Somebody else might want to talk about it for about an hour, though. Don't tell Judge Siegel I picked on you. She'll be mad at me.
I'm sure she's fine.
Okay, all right, so that completes the witnesses in favor of the nominee. Before you give your statement, well, let me ask you this. Are there any witnesses in opposition? I saw a lot of protesters out there. I don't know if they were for you, but, okay, hearing none, I'll close the witness portion. Why don't you introduce whoever you got here, and then we'll hear from you.
Yes, as you know, my two best friends on the district court who just spoke for me, Michelle Fentress and Jason Chan. And I thank them for speaking on my behalf today. And I have my father, Dr. Clement White here, and I have my wife, the Honorable Fabiola White, who is here.
Judge White.
Sorry,
Judge White.
the Honorable Judge Fabiola White, excuse me. My apologies. May I begin, Counsel?
Please.
All right. Good afternoon. I would first like to thank Governor Healy and Lieutenant Governor Driscoll for giving me this opportunity. I also want to thank Paige Scott Reed, Dara Kesselheim, Jesse Boodoo, Valerie McCarthy, Sonia Altamirano for their assistance in making this a smooth process. And thank you to each and every member of the Governor's Council for taking the time to read my application, spending time with me prior to today's hearing, and considering my nomination. I also want to thank my family. As you know, in my two-judge home, I am the second most impressive and second most powerful judge. I am ranked 2 out of 2, but that is okay. The best thing that ever happened to me was starting my career in Roxbury Court 20 years ago, not because of what it brought to my professional life, but it is where I met my wife, the Honorable Judge Fabiola White, who has been my partner in every case I've had as a lawyer, every job application, and every judicial application. Together, we have raised 3 children, my 23-year-old son, Amari, who was a graduate of Providence College, and who has the fearlessness I wish I had at his age, my 12-year-old daughter, Avani, who can play almost anything on the piano and violin without any written music in front of her, and our 9-year-old son, Asir, who can explain to you the finer points of Greek mythology without flinching. And of course, my father, Dr. Clement White, and my mother, Dr. Jeanette White, who gave my brother Sekou and I, the best of everything, but especially gave their unconditional love, respect for our cultures, and belief in us. They came from small islands with big dreams, limitless ambition, and an unyielding dedication to their children. In my career, I have had the tremendous honor of being mentored by the best people in the legal profession. First, Judge Bill White, who I call the original Judge White. I want to get rid of all past, present, and future confusion. We are not the same person, and we are not related. However, he is my unofficial big brother, and it is my dream. My dream has come true to possibly join him on the Superior Court. Justice Geraldine Hines, the first African-American woman to serve on the Supreme Judicial Court, who gave me an internship in 2003 when I was in law school, when she was a new Superior Court judge, and allowed me the chance to watch the court and her operate. I am honored to have the chance to sit where she sat. Justice Roderick Island, the first African-American man or person to serve on the SJC, who gave me his time, patience, and advice when I decided to apply to be a judge. I would also like to thank Judges Gloria Tan, Jeffrey Locke, David Frank, Emily Carstetter, Marianne Hinkle, Sabine Coyne, Charles Gross, and of course, Jason Chan and Michelle Fentress. I would also like to give special thanks to Chief Judge Stacey Forts, who helped steer my career since I was a third-year law student and gave me my first shot when she hired me at the Suffolk County District Attorney's Office in 2004. And a special thanks to all my colleagues and friends at the Woburn District Court for all of your support. I would also like to acknowledge my most important mentor, my law school professor, Susan Mays Rothstein, who I refer to as my legal mom. Professor Mays Rothstein taught me the importance of consistent, thoughtful, and intensive preparation, and shaped every facet of who I became as a lawyer and a judge. Members of the council, I came to Boston in the fall of 1997 as an overwhelmed and pensive incoming college freshman. Though I was only coming from an hour away in Providence, it might as well have been a world away. That is because my life was at the crossroads of pain and possibility. That fall, I entered Boston College, never thinking that the beautiful struggle of my adult life would lead me here almost 30 years later. As you know, I came before this body 4 years ago when I was nominated to the district court and eventually became first justice of the Woburn District Court. My core principles on the bench have been driven by the perspective that I gained through the difficult life challenges that I referenced a moment ago. Every day, I see young men and women who come before me who lost a parent at a young age, as I did. Every day, I see people who come before me who became young parents, as I did. I see folks who, like me, emigrated to this country and did not start life with massive financial or political capital, and must navigate a world where their value and potential is underestimated, as my value and abilities often were. Not in every way, but in some meaningful ways, I have stood where they have stood. These experiences not only gave me empathy for others, but a sense of responsibility and obligation to ensure that everyone who comes before me is heard and treated with dignity. My decision to apply to this position does not speak to my lack of love for the district court, but rather to my years-long affinity for the Superior Court. This is because in the Superior Court, the depth of legal issues that judges see and the breadth of the kinds of cases that judges see are unmatched. But beyond the resolution of complex matters, the court deals with the hardest issues in society: crime with its most tragic consequences, criminal defendants facing the most severe penalties, civil plaintiffs seeking redress for substantial damages, and civil defendants facing possible financial ruin. I know this because as an attorney, I practiced in the Superior Court for several years, first as a prosecutor, then as a civil litigator, and then as a criminal defense lawyer or bar advocate. In those years, I handled everything from car accidents, drug trafficking, firearms, child abuse, sexual assaults, all the way up to homicides. As a prosecutor, I have sat with victims whose lives were irreparably changed by callous acts of violence. And as a bar advocate for almost a decade, I sat in gloomy jail conference rooms, jail tears, and one time a jail cell with defendants, many of whom were barely adults, who faced a literal lifetime in prison. I believe now what I believed then, that where the issues are the most complex and pressing is the place where I can make my biggest contribution. To be sure, I know that I have lots to learn. This is a different court with its own challenges, and I will be committed to learning from the chief and my new colleagues. But I can say that my foundation of who I am will continue to be the same on the Superior Court bench if confirmed: to be guided by the rule of law, to use my discretion wisely, and to use my authority with restraint, and to be fair, just, and kind to all. Thank you, and I look forward to your questions.
Thank you. Councilor DiPaolo.
Thank you, Counselor. Good afternoon.
Good afternoon, Councilor.
Congratulations on your nomination.
Thank you.
Ever since you were one of the first folks appointed when I first got on this council.
Yes.
And from that time, Councilor Kennedy has been talking about how we're going to see you again. So here I am, seeing you again. Congratulations. So we had the chance to speak briefly ahead of your hearing. One of the things we touched on was how the courts go about reflecting on their practice and how we can kind of have a culture of continual improvement. And part of that is being data driven and having a clear picture of what's going on in our system. So I'm curious, from your perspective as a practitioner, as a district court judge, what kind of data would be helpful, do you think, for the court system to identify and address areas potentially of concern?
Sure. A few years ago, and I know my colleague Judge Fentress mentioned it, there was a Harvard study that looked at disparities in sentencing, mostly focused on sentencing, and found ultimately that most of the disparities originated from decisions to charge and prosecute and arrest. I think continuing to look at that data is important. And I think one study certainly is not enough. Sentencing is something I think we should track yearly, frankly, and to see what the different trends are. I think in addition to that, I think it is also important to look at data as to probation violations and how judges are sentencing on probation violations, especially in the district court where most of the criminal cases are. The bulk of people either are avoiding jail and are on probation, or serve some incarcerated time but are on probation when they are released. I also think, Counselor, and I'll just say one more thing. I also think that we should also look at the impact of on people's employment or housing or family care when they have to come to court several times. I'm a proponent of Zoom, and I, from my criminal defense experience, that when people have to come to court several times, it can have a really negative impact. Certainly, if they're in custody, that would make it far worse. I think we should keep track of those 3 data points.
To your knowledge, and pardon my ignorance, is this being gathered routinely now, or is it?
I know the district court routinely, we have staff on the district court that routinely gathers data when we ask them to. And for presentations that we have done for the Race and Ethnic Fairness Committee, we have had wonderful people in the district court who have taken the time to gather those numbers so we can make more full presentations. Outside of that, I do not know if the data is being gathered.
And it's not for you to answer, but in the Gantt study, the Harvard study, I know one of the takeaways was how hard it was to accumulate the data.
Yes.
That they did, and how it was even what they did was still imperfect because some agency, there's so many stakeholders.
Yes, sir.
Right, who aren't gathering evidence in a coherent way relative to each other. It's an
Yes, sir.
interesting problem to look at. And just in terms of what you were talking about and the exposure to prolonged sentences that Black and Latino defendants in particular face happening at the charging phase in those clerk magistrate hearings, I would suspect, right? I think it was 50% more likely that Black and Latino defendants would end up in superior court when there was concurrent jurisdiction than a white defendant. We've all heard about what you've done in the district court. I look forward to supporting you. I have no further questions. Thank you, Counselor.
Thank you. Counselor Jake?
Thank you. Hi, good to see you again.
Good to see you.
I really enjoyed our chat and we covered a lot of ground. I kind of want to dovetail off the prior questioning and take it in a slightly different path, but do you believe it's important to have judges who are representational of the communities who come before the bench?
Yes, I believe it's important.
What do you think is why? Why is it important? Why does representation matter in the courts?
I think representation matters. I'll point to 2 what I think are critical reasons. I think there is value when people see themselves represented any place that they go. There's limitations to symbolic value, but I think there's something meaningful about that, and people, for a variety of reasons, feel more comfortable and have a sense that they may be treated fairly because people who look like them are in decision-making positions. But I think in addition to that, people of similar backgrounds can often have similar experiences. That is not always the case. People with the same background don't have exactly the same experiences, but often because of similar racial, ethnic backgrounds, that people might have similar life experiences, and it might make them a little bit more insightful or empathetic. And that's not to suggest that someone cannot be insightful and empathetic if they're of a different cultural background, but I think it adds to that possibility.
No, I appreciate that. So if I'm not incorrect, I think there are 82 Superior Court judges in Massachusetts.
I believe so.
I I know the numbers have changed with the Haley administration's nominees, so I'm not entirely sure what the statistics are at the moment, and I'm not expecting you to have your finger on that either, but historically, there was a real lack of diversity at the Superior Court. Even with the nominees that have been added recently, my perception, and I'm hoping to have hard data soon. I know people are collecting it, trying to really assess sort of the lay of the land now, but still an underrepresentation of people of color, people representational of other marginalized communities as well. Women, you know, just on just a lack of diversity that maybe is slightly ticked in the right direction, but still, I think, is underrepresented. And I'm just curious what your thoughts are in relation to the prior questions about the Gantt studies findings, the racial disparities that we know show up in sentencing, incarcerated populations of color, outpacing enormous factors. What your thoughts are about what impact might be seen as Superior Court reaches a level of diversity that's representational of the makeup of the state. Do you think there would be an impact? What impact might there be?
I think there would be an impact. I think diversifying the bench is a positive thing. And I think when you add different experiences to any room or any environment, I think it's to everyone's benefit.
And the last thing on data, and then I'll move on to other things, but you know, I did find the Gantt study fascinating, and it feels very old now, and I'd love to see it refreshed. And one of the main takeaways when I read it was the challenge around the lack of transparent and easily digitally evaluated data in the state, which hopefully, again, that was so long ago, and COVID has happened, a lot of technology was brought into the justice system, so I'm hoping it's easier these days to collect and look at trends, but you can only evaluate data trends on data that you're collecting. And so even if there's the racial, there's more than just racial is what I would like to see what the trends are for you know, based on socioeconomics, based on housing status, based on sexual orientation, based on disability, based on, there's so many things that are, we know there is implicit biases that have an impact on outcomes, that if you're not collecting this data in a disciplined and consistent way across the state's systems. Like I appreciate what you're saying about what's being collected, maybe ad hoc as it goes along in the court, but you know, there's an opportunity probably at the clerk's level to have forms that include demographics and other factors that might reveal trends that we otherwise couldn't assess without having the data on hand. So honestly, I don't even have a question there. That's just a statement. I'll just leave that as a comment.
Yes.
I would like to see that happen. And I know there's interest in particularly the racial side of the disparities that we know based on that study, but there's more than that. There's more factors at play that are important to consider. I only one other area, and then I'll move along to give other counselors an opportunity, but we didn't spend a lot of time talking about it, but I am, you alluded to, you know, looking forward to learning and growing, and I'm just curious what areas you think might prove an immediate challenge where you are anticipating having a growth learning curve ahead, and you know, what those areas are, and just to speak to your approach to how you do dive in on new areas that you want to an uptick in your understanding.
Sure, I expect everything I see on the Superior Court to be a challenge and to be an adjustment for me, because I've mentioned it is a different court. But if I had to select one area, and I say area in quotations because it's really one gigantic area with different sub areas, I would point out the civil docket, the civil session in the Superior Court. It's voluminous and it's large in the district court, but even far bigger in the Superior Court. And you see a wider range of the kinds of civil cases in the Superior Court. And civil's really a catch-all term for like 50 different areas of law. So You have contract disputes, you have labor disputes, you have injunctions, you have declaratory judgments. Some of those that will be new to me, some I've had some experience with. So I think managing that intense and voluminous of a civil session will be, that's the thing that stands out in my mind the most.
And so what's the approach you take when faced with information that you?
Oh, my apologies, second half of the question, I'm sorry. Yes. So the approach I take is twofold. Number one, I think there is no replacement that you have to open up a book and look at the rules of civil procedure, and there's just no way around it. It's rule heavy, as we say on the civil side, and you have to open up a book, you have to read it, you have to read the case law, and there's just simply no replacement for that. Then I think you have to rely on your more experienced colleagues. You have people who have been on the Superior Court for several years, many of whom had large civil practices before they got on the bench. And those are the people you have to rely on. Also, I think an underrated piece is to rely on the lawyers. The lawyers know the case. You have very experienced lawyers who come to the Superior Court. And many times in the District Court, I've said to the lawyers, can you educate me on this, please? And the best lawyers know that their job is to educate a judge. And judges really appreciate when we have lawyers who are ready to teach us about the issue at hand. So that's my plan to approach it.
Appreciate that. All right, well, thank you very much.
Councilor Dolan.
Thank you so much. Congratulations on your nomination, Judge White. I really appreciated your taking the time to meet with me. I enjoyed our conversation and could see the thought and depth of experience that you put into your work, into your answers. And I also want to thank you for your service as a bar advocate. For folks who don't know, those are public defenders. Yes. And I also appreciate insights that gave you. And so I wanted to start with one question that pertains only to Superior Court judges, and that's 58A appeals. For folks who don't know, that is often inappropriately and unfortunately referred to as the dangerousness statute, but it should be referred to as the pretrial detention statute. It relates to whether someone is held in custody or subject to conditions prior to trial. As you know, if someone is held following 58 hearing in the District Court, they can appeal to Superior Court. One of the current concerns that I have is that Superior Court judges are not necessarily very familiar with some of the folks who appear before them in those hearings, and that they may see certain things as indicators of dangerousness, which aren't. Can you speak to that issue and how you would approach those appeals as a Superior Court judge?
Sure. So on the District Court, in the courts that I've sat in, the 58A hearings are routine. And I hear them, if not every day, at least 3 or 4 days a week, I hear 58A hearings. And the penalty, if you find someone is, there are no conditions of release that can assure the safety of the public, is 4 months in the District Court, 6 months in the Superior Court. So it's pretty severe if you make that decision. And it is important, whether it's the first hearing or an appeal, to make sure you're treating everyone as an individual, and you're not making a decision based on simply because the Commonwealth moved for this means it has to be true, or you have to agree. So you might review the material and believe that there are conditions of release that are sufficient to release that person. So I think that because I've had some experience as a District Court judge, and because I have a lot of experience as a bar advocate, meeting with clients, there are things when I look at a record and I see certain kinds of convictions, it doesn't necessarily automatically say to me that this person is too dangerous to release. Records can be misleading after you get to know a little bit more about the person. Police reports are often based on double and triple hearsay, and you have to listen to cross-examination and the presentations of defense counsel. So you can't take anything at face value when it's a 58A hearing or any kind of hearing. So I don't think there's anything for me where I would say automatically I believe that person is quote unquote dangerous simply because they come before me at a quote unquote dangerousness hearing.
Thank you. The other thing that only Superior Court judges do is hear Mary Mo appeals. As you know, anyone who is under the age of 16 and wants an abortion in the Commonwealth of Massachusetts has to have the consent of either a parent or an adult guardian. And if they can't get that, they only have one thing left, which is to go before a Superior Court judge and get an authorization for an abortion. What criteria would you use to authorize an abortion for someone under 16?
Well, I've never personally seen one or been involved in any of those kinds of petitions. I did do some research as to what the legal standards of those petitions are, and I would follow the appropriate legal standard. It does leave a judge some latitude and discretion to make that determination. And I think judges have to find if that person is competent to make that decision, or in the alternative, it is in that person's best interest. That's my understanding of the legal standard. So it's difficult for me to say beyond that, but I will say that generally, I believe that it should be between the petitioner and their medical professional as to whether or not to proceed with that sort of procedure.
Thank you. And I wanted to ask you about your time as a prosecutor.
Yes.
You worked in the Suffolk DA's office and you became the lead prosecutor of the gang unit.
I was not the lead prosecutor of the gang unit. I was not the lead. No, I was not. I was the lead prosecutor at the AG's office later on. Yes.
Prosecutor of the gang unit, you were
Yes.
the gang unit at the Suffolk DA's office. And so you're familiar with the gang database.
Yes.
Which is relied upon by police departments and therefore by prosecutors. Could you just talk about your experience with the gang database, how you view it? And we talked about all of this and what you would do as a judge to make sure that the gang database was not relied on to excess.
Sure. In terms of my experience with it, I did serve in the Suffolk County District Attorney's gang unit in 2007 and 2008 as part of my responsibilities. I went to what I can call intelligence sharing meetings with the Boston Police, where the gang database was shared with us in a presentation, and we were given a copy. So I do have experience understanding what the gang database is. That was some time ago, so it may have changed since then, but that is the basic outline of it. As a defense lawyer, I then received it from prosecutors who were intending to rely upon it, usually in a motion to suppress to justify a stop or a search. And it was roughly the same idea as when I was a prosecutor. So I do have some experience with it. My opinion on the gang database, I think that obviously I'm supportive of police departments trying to gather information for people who may be causing a problem. I think there are issues with the gang database because I think it is very easy for a young person to be put in that database. So it's a decision of a law enforcement officer who unilaterally decides this person's name should go in a database.
Due process before you
No.
gang database.
There is not. It's not vetted through a judge, and honestly, it's not vetted through a prosecutor. It's put in by a police officer. Sometimes they may be correct, and there are other times that they are not. And I do have a concern where there may be a group of 2 or 3 kids that hang out together a lot and may have gotten into some sort of trouble and live in the same neighborhood. And the police then characterize those kids as such and such street gang, where that might not be the case. In terms of what I can do at a hearing, and I argued this several times as a defense lawyer, and I would follow the same strategy as a judge. In order for me to take into consideration whether or not someone is gang involved to justify a stop or search, the Commonwealth is going to have to meet a certain quantum of proof in order for me to take that into consideration. The fact that someone in the gang someone is in the gang database without any other information, in my opinion, is woefully insufficient to make that determination. And if that is the only piece of information, then I would say it's insufficient. So the district attorney has other ways and other options to beef up that information, and I would expect that they would do that.
Thank you. And I just have one more question
Yeah.
for you. As was discussed earlier, Commonwealth versus Long, which I believe is one of the most important decisions that the SJC has handed down in recent years and has the power to end racial profiling in Massachusetts by changing the burden of proof for those who want to establish that race may have been a factor in making a stop. And yet, since long was decided, last time I checked, only 3 long motions have been allowed. I personally find it difficult to believe that the number of denied long motions is due to lack of merit on the defendant's arguments. So I'm very troubled by that. And I would just like to hear your thoughts on whether you've heard long motions in district court, and your view.
Yes, I have heard long motions in district court. I think I've only heard about 2. So I have not had many that were filed, at least when in the courts I was sitting in. I know casually from some of my colleagues in Boston that they've heard more than I have. I don't know the data on which courts are hearing them more, so I don't want to speculate, but I know that there are other courts where judges may be hearing more than other courts. I think it is an important tool. I agree. It was one of the most important decisions in the last decade. And if someone files a long motion in front of me, I take it really seriously. I would apply the appropriate standard and take it from there. But I think the essence of your question is I would not dismiss it, certainly, if someone files a long motion.
Thank you. I just want to add, I have not personally experienced this, but I've
Yes.
had colleagues tell me that they've experienced long motions where they were denied even a hearing. I don't know what possible basis there was for that, but I trust that you would not wrongfully deny even a hearing on a long motion.
I do not expect I would.
Thank you. No
Yes.
further questions.
Councilor Iannello?
Thank you very much, Mr. Chairman. We had a nice conversation, on the phone. Very impressed with, the witnesses today. They've both done a great job in the district court. They're clearly gonna miss you. The biggest supporter though here is your counselor, Counselor Terry Kennedy. As soon as your name, was nominated by the governor, he called me right up. Big supporter. He says, you're fair, you treat people with dignity and respect. He gave you high marks. And then when I drove in today, because I was at my law office, and Counselor Judicial picked me up. And again, another big supporter. He says, I remember him, he's a good guy, definitely, he's a good guy. And I hope I'm not saying anything right. He says, I think there's 3 judges on board, they're all good people. So maybe he was talking about you, I don't know. But no, really, I have no questions. I think you're gonna be a great addition to the Superior Court. It's great to see your father here, your wife here. We got next week or whenever your name comes before the council, we'll be more than happy to support you.
Thank you so much, Counselor.
I think it's gonna be in about 20 minutes next week. How many times have I appeared in front of you?
More than I can count.
Me too. Hundreds and hundreds and hundreds of times. And not I've only personally appeared in front of you hundreds and hundreds and hundreds of times. I can't count. I've also seen how I've been in the courtroom where and seen how you've treated other people. And in my estimation, in terms of demeanor, you are the model that every judge should go by, from the juvenile court to the SJC. You have a perfect temperament on the bench. It's, sometimes I've sat there and watched some of the things that go on in courtrooms, and when you're the judge presiding over the session, I sit there and shake my head and I say, how can he be so patient? I would have lost it a long time ago. Maybe that's why I never became a judge, because I can't be that patient. You take every issue seriously, you think about it, you analyze it from a legal perspective. I've seen you take a recess and go off the bench and come back and bring back case law and start applying it to the facts that you just heard, which you don't see a lot. You do that right in the middle of a motion, right in the middle of a trial, and you're going to be perfect in Superior Court. My big regret is that you're not going to be in District Court anymore. You're going to be a great loss to the District Court, but a great addition to the Superior Court. I personally am going to miss you. You won't see me up in Superior Court. Trying to get away from that. I don't want to work that hard anymore. I am 67. I got to slow down a little bit. I can't try. But I do have trouble keeping up with my older colleague, Councilor Iannello. moves faster than me, but. So, hopefully in about 10 minutes, I'm gonna put your name in nomination. We're gonna have an assembly and a vote. That's it. We're done.